Welcome to The Legacy Cast by Kelley Legacy Law.
Hey everybody, welcome to an all-new episode of The Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. I'm your host, Mike Leon. You know, their practice focuses on helping families enhance their lives today and secure their futures tomorrow. And in today's episode, we're going to be talking about what it really means to serve as an executor or administrator and why understanding those responsibilities of that role is so important. Mike, good to see you as always. Let's talk about this because families often choose an executor without even knowing what that job title actually involves. So how do you explain to them the responsibilities in plain terms?
Yeah, thanks for having me. I always enjoy educating the public as much as I can about these issues because they're so crucial. I can speak to the difference in what those terms mean in my state, in Alabama, and typically, you know, across most states, we use similar terminology. In Alabama, an administrator is someone who's appointed when there's not a last will and testament involved. So somebody dies, they had no will. We have to go to the court and file a petition for what's called letters of administration to administer someone's estate. So the person that the judge appoints is called an administrator. Now, an executor, on the other hand, is someone that's appointed by the person who has drawn up their will. So they've chosen, okay, I want this person to serve as my representative when my estate's being handled. Now, in Alabama, we use the term personal representative globally to cover both of those things. So whether you have a will, whether you don't have a will, technically it's your personal representative, although we still kind of use the old terms as well. A fiduciary is someone who has a heightened legal responsibility to act in the best interest of the people that they're representing. So, you know, an executor has a fiduciary duty, an administrator has a fiduciary duty to protect the assets for the ultimate people that are going to receive them. So, and for the creditors for that matter, to make sure they get paid. If we were talking about a trust situation, then we're talking about a trustee. They have a fiduciary obligation to the beneficiary. So those are the differences.
And then piggybacking on that, what are some of the most important duties? Let's go into the executor part of this. What are some of the most important duties that they have that they're responsible for when someone passes away?
Yeah, I mean, first and foremost, again, it's going to be protection of the assets. So, you know, once someone gets appointed as the personal representative of an estate, their first job is going to be, you know, to make sure that they identify the assets of the person that passed away. You know, where are they? How do we get access to them? If it's a house, we've got to make sure that we're going to keep paying the mortgage, keep cutting the grass, paying the water bill, getting the mail, making sure that we're paying the property taxes so that thing doesn't go into some kind of, you know, tax sale. I've seen that happen before where we got into an estate really late. The taxes had not been paid, and we had to redeem that through Alabama's redemption process to get it back from the person who had bought it at a tax sale. So there's a lot to it, you know. Bank accounts, usually what we do is we will get a tax ID number for the estate, which is its own separate legal entity. We'll set up a bank account with that new tax ID number, and we'll transfer liquid assets from the different places that the testator had them into that bank account. So asset protection, number one. Number two, dealing with creditors. So people need to understand this is not an honorary title that they've been given. Like that, it's an honor that somebody would ask you to do this for them, yes, but it's a job. So you're going to be fielding calls from American Express and Ford Motor Credit and whoever else that had, you know, a lien or was owed money. Maybe it's a final medical bill from the hospital or something like that. Those folks are entitled to get notice that this person passed away, which is also your job to notify people that we know about that are owed money. So we're going to field calls and keep them, you know, informed about what's going on and when they might expect to be paid.
You know, I love that you said that they get caught off guard because when someone's named an executor, you mentioned a bunch of different scenarios there, but are there any other challenges that usually catch them off guard? Like, oh, like when you just mentioned, hey, this person's died, you got to tell folks that this person is dead.
Well, you know, depending on if there's a will or if there's not a will. Okay. You know, if there's not a will, then people are really surprised to see all the hoops they have to jump through because, you know, in order to be appointed as an administrator at first, you know, somebody dies without a will, you've got to go get an insurance bond to cover the value of the assets of the estate. Well, in order to get an insurance bond, I've got to tell this insurance company everything about my personal finances. because they're basically ensuring me that if I get appointed as administrator, take possession of the assets of this deceased person, and then I spend them all on me or I lose them somehow, the insurance company's got to pay that money back to the estate for the mistake that I made. So I've got to tell this insurance company all about my personal finance, which some people are a little bit shy of doing. They're saying, well, I'm trying to do this person a favor serving as executor. I don't know why, or administrator. I don't know why I have to tell the insurance company all about my money. But you do, if you want to get that bond. Also, they have to file a complete inventory of all the person's assets that, passed away. And so there's work to do there. They have to ask permission from the probate judge to sell a piece of real estate or sell personal property. They can't just do that because they think it's in the best interest of everybody. The probate judge here has a vested interest in making sure that everything is carried out to a T the way it's supposed to. So the administrator is going to have a lot of oversight from the court. That's why it's really crucial to have an attorney helping you if you're going to be trying to do something like this. So I would say just the time that it takes, the things that you have to file, and all the work that you have to do along the way procedurally to make sure that everything's done the way it's supposed to be. Because as the administrator, you can be held accountable if you don't do it right.
So piggybacking on that, then you meet with clients all the time. What qualities are you encouraging them to look for when they're deciding on who should take this responsibility?
It's a hard thing for people to decide because most of the time, married couples, they may say, oh, it's easy to choose my spouse. Okay, we want to do that. But when it comes to the kids, now we have an issue. Do we name one child? Do we name all of them? It's a struggle between what's probably the best decision to make financially and what they think is fair. A lot of folks would rather not hurt one of their children's feelings than appoint the child that they know will be the right person to do this. Because, and it seems like in every family, especially where we have 3 kids, we've got one kid that's great with money, but then another kid who we want to make our healthcare decisions. And then, another one may live way off and they're not going to be involved at all. So, you want to find somebody that's trustworthy, that's going to follow the letter of the law, that's going to look out for, the other people, if it's a will listed in the will, who are going to receive things. Somebody that's going to be very responsible and take the job seriously. And it's going to do their best to keep bias out of it, because at the end of the day, the executor, like we said, has that fiduciary duty.
You mentioned a moment ago about people finding out, that there was no will in place and all the hurdles that they have to jump through. So on the flip side, how can a well-prepared estate plan really make the job easier and less stressful?
Yeah. If a will is drafted properly in Alabama, then your drafter or your testator who's, signing the will can do a lot to alleviate the burden that's on the executor, because you can exempt your executor from having to do a lot of the things I just mentioned. So you can put in your will, they don't have to post an insurance bond. They don't have to file an inventory. They don't have to file an accounting. They don't have to get permission to sell real estate or personal property. So essentially, with our will drafted properly, we can kind of tell the probate judge, okay, we've got this. We will contact you if we have an issue that comes up. But legally, we're able to do that. So the probate judge can then kind of sit back and just monitor things and be there on an as-needed basis. So it can make life a lot easier on our executor. And they still have the same time frames that they have to deal with. They still have to deal with creditors and that kind of thing. But a lot of the procedural hoops they can be exempt from.
So, Mike, for someone who's listening to this right now, they've been named an executor, either somebody passed away or they just got named it right now. They feel a little overwhelmed. What's the first step that they should take?
Well, first thing I would do is, if they've been named executor, they need to have a real conversation with the person that named them about what exactly that means. They need to find out, okay, what's the size of the job that I'm being asked to do here? What kind of assets does this person have? Where do they want them to go? The biggest issue we have with probate, litigation or will contest is surprises. Okay. I'm a big advocate for transparency. So, if you make an estate plan, at least let your executive or your trustee, if you do a trust, that kind of thing, at least let them know, okay, this is the plan. Now, if someone has just passed away and you're the executor and you really haven't looked into this, I would go see an attorney because, the best thing you can do is educate yourself immediately on whether or not this is something you can do by yourself. Legally and technically, you can, as an executor, go through the probate court process without the help of an attorney. All right. But it's just like anything else. I mean, if I had a cyst in my side, I could cut it out myself with a scalpel, but I'm better off letting the doctor do it. Right. So that's what I would say. Get legal counsel to help, because ultimately, even though you're going to have to pay an attorney, it's probably going to save you a lot of time, money, and heartache at the end of the day.
Yeah. Mike, we truly appreciate the time and insights on all of this.
Yep. Thanks for having me.
And thank you for everybody out there listening to another installment of the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. To connect with Michael and the team, do me a favor, head over to kellylegacylaw.com today. Don't forget to leave us a review and comment, or share this episode with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.